Thank you all. There are a lot of jurisdictions that are rethinking their reliance on money bail, but I don't think most people recognize how far DC itself has gone toward road testing an alternative system, and for how long. Judge Morrison, a couple of years ago, you told the Washington Post, there is no evidence you need money to get people back to court. It's irrational, ineffective, unsafe, and profoundly unfair. So what has DC learned in its over 2 decades about what it takes to create a system that does not rely on money bail, and how applicable could that be to other jurisdictions?
We have learned that judges do not need money to be successful, and that you can operate a big criminal justice system and have it be safe and effective and fair without using money at all.
At all.
We have been an example of the ability to do that successfully now for decades. The tragedy is that the rest of the country, judges almost everywhere, their default tool of first recourse is to decide liberty pre-trial based on people's wealth rather than our best estimate of their likelihood to succeed, which almost everybody will succeed.
What is the major alternative DC has used to, is there one principal alternative, or are there just many?
We outlawed basically detaining people with money. We changed one sentence in our bail law in the early 90s that completely transformed us, and it said that judges can use money bonds if they want to. They're legal in DC, but they can't set a money bond that results in pretrial detention. In other words, you can't. Everybody has a right to a money bond that you can meet in the District of Columbia. So tonight on 19th Street in our jail, if you walked the forlorn halls with me, you would not see one woman or one man sitting there too poor to get out. There's no other jail in the United States where that can be said.
So California has just taken a big leap in a similar direction. Talk a little bit about SB 10, why you felt it necessary to deal with this, and how you expect it to change the system.
Thank you. First, thank you to The Atlantic and to the MacArthur Foundation for hosting this and inviting me here. California, I think, has just shown with the passage of SB 10 that we agree with Judge Morrison and what Washington, D.C. has done. And we literally looked at their experience, their leadership, what they did with respect to eliminating money bail and what they used as a replacement. We felt in California that we had a fundamentally unfair, unsafe, unjust, ineffective, immoral system based on money, where the jailhouse door was literally swinging open and closed based on how much money you have in your pocket, where people were, their liberty, decisions about their liberty were made based on the size of their wallet instead of the size of their risk, and where it was pay to play. If you had the money, even if you were a risk to the community and you were not going to appear to your next hearing, you could buy your way out of jail. And even if you were going to show up for your next hearing and you're not a risk and you didn't have the money, then you wither away and suffer in jail. And poor people were getting punished for being poor. We thought that was absolutely wrong and it needed to be changed. Massive human impacts, people, because they're in jail, losing their jobs, losing their cars, losing their housing, losing their kids. And we wanted to change that. We wanted to end that anguish, that suffering, that pain. And we set about to change it. And over 2 years, we did.
I want to return to the debate over SB 10 in a minute, but let me ask you, you have written something I found interesting. You said, there is no magic bullet, quote unquote, to reforming bail. So does that mean the same approaches don't necessarily work in all jurisdictions, or even for all people in the same jurisdiction?
So what I mean by that is eliminating money bail is step one. And what California has done is remarkable, because not only is it taking money out of the equation, it's also eliminating a bail bond industry that has preyed on Americans literally for decades now. So that is huge. But that is actually not the only key reform needed to do bail reform right.
It'll
the
be
second
up to me
piece
to kind of
is...
If you go too hard in the beginning, I will calibrate, so don't worry too hard.
Well, I don't know. The second piece that is that is critically important. I would say actually more important than simply eliminating the role of money is making sure that fewer people are in jail as well. And one of the challenges, right, when we've seen this in Washington, D.C., that has essentially stopped using money bonds now for almost 30 years, and it's to be seen in California, is can we actually not impose what's called preventative detention, where people just end up being in jail without any option of getting out? Can we not just substitute one sorting mechanism for another? If not cash bail, then we're just imposing preventative detention instead. And that is actually, I think, the real challenge with bail reform, is can we implement this right so that there are fewer people in jail, not simply just people in jail simply who are there because they are too poor. Those are two different elements that are both key.
And that is precisely the debate in California, where you had some of the usual allies, the ACLU in particular at the end, come out against SB 10 because they felt it gave too much discretion to judges, in particular, in ordering preventative detention. What were you trying to achieve in those provisions? And how do you respond to the concerns that some of your usual allies have raised about what the final product looked like?
Yeah. You know, the replacement system we proposed in SB 10, and which is now the law in California, is based on the fundamental principles that are used in Washington, D.C., and Kentucky, namely a risk assessment tool, a robust set of pretrial services to oversee the safe release of individuals, the presumption of release, where if people can be safely released, they will, and then we have limited judicial discretion. And I think that last component was where some folks got concerned. We put guardrails and limits around judicial discretion, but we did do what Washington, D.C. has done, which says that under certain circumstances, basically if there's no condition of pretrial release or a combination of conditions that can reasonably assure the appearance of the individual and the safety of the public, then they could be detained. And that's meant to be limited only in the rarest of circumstances, but it's there. And some of the folks in the coalition were not trusting of that judicial discretion, but we think it's limited, and we think it's an important part of an overall risk assessment regime.
So I really agree with her that we can never have bail reform in America unless we eliminate money. Money has no place in anything that calls itself a justice system. But that is only the first step, and I travel the country selling something that I fought as a young lawyer here in Washington, which is preventive detention. And I sell it because if we just eliminate money, everyone goes home pre-trial. I believe almost every single I believe with Chief Justice Rehnquist in the 1980s that release is the norm in America, and almost everybody can safely be trusted to come back and not get in trouble. But there are always going to be, in my view, a few people who present a challenge in terms of their ability to succeed pre-trial that we can't mitigate. We have to struggle to mitigate that challenge, but there are always going to be a few people. For those people, judges have to have a way that's due process, appropriate, lawful, open, and transparent to hold those people, rich or poor. The key is to keep it limited. And we finally, after decades of fighting to get people to realize you've got to get rid of money, we're not yet quite ready to help them when they ask, okay, we're going to change to what? Change to preventive detention, in my view, that is extremely limited. And as we give that power to judges, we have to limit it at its genesis, at its birth. We can't just leave it up to judges. We have to limit their ability to use preventive detention.
And you think it is possible to limit it in that way, that you can draw limits that will be meaningful?
Yes.
And set standards that people can kind of look at from the outside and see are being
There are
consistently
scholars
applied.
who are writing about this. The most important one is a guy named Tim Shinaki. And the short answer is yes.
Do you agree?
It can be done. So I was a public defender. That's how I started my legal career. And what we saw in New York City, which is where I practice, is that even though there is a cash bail system there, judges used it rarely rarely and only when charges were really serious. And that is, in fact, the right way to think about whether it's through a money bail system or through a system that doesn't rely on money bail at all, how do we very narrowly only use detention for cases where there's no safe way to have this person either return to court or to be safe in the community. And New York City, which is a place that has cash bail, actually is doing that at rates comparable to Washington, D.C., which I think is a little known fact. But in New York, when you step right outside of New York City, where it's really about judicial culture, where judges have said, well, we have a good subway system, we have good pretrial services, we're comfortable releasing people even if they haven't shown up to court in a previous case because we think we can get the supports right. When you don't have that culture, when you don't have the resources and the infrastructure, then the default is for judges to set bail to hold people in because they're worried about their appearance at the next court date, or they're worried about what will happen if that person is in the community. But I think it's possible. It's a culture question.
It can. By the way, I think it is possible that your hair is contributing its own commentary to the conversation this afternoon. So
That is
we might
also
we did
completely
not.
possible.
We'll need another chair. So let me ask you this, and I want to start with you because, I mean, California is not the only place where there are complicated cross-currents here. We have been in a number of cities where there's a lot of interest in risk assessment tools as an alternative to the existing system. On the other hand, there was a coalition of over 100 civil rights groups that put out a statement arguing that these tools, perpetuate racial inequities already built into the system. How do you balance that? What is your take on the right way forward on using risk assessment tools?
So risk assessment tools, I think, have taken up this big space in the bail reform sort of conversation that I actually think sort of sidesteps the real issue, which is about limiting that detention net that the judge spoke about. Risk assessment tools are actually, they can be used for good, which is to say quickly, efficiently, these are people that we can release. We're sure they'll come back to court, or we're sure they will not pose any, community safety risk while released. There is a valid use for this shortcut, which is essentially what risk assessment instruments are. Where they pose a really big problem and pose legitimate concern from civil rights groups, from people who care about racial disparities, and we know we have a criminal justice system that has racism baked into its very core. Where it causes concern is, are the racist factors in policing, in convictions, in sentencing, does that get baked into the data and the algorithm that's then used to create these risk assessment instruments that's then used to make decisions about detention? So that's where the concern really lies.
How did you deal with that in SB 10, that question? Risk assessment in general, and then the concern that it merely kind of, it incorporates into an algorithm the existing inequities in the system.
Well, the risk assessment tool was always a desired component of bail reform, and the ACLU wanted it. Even folks who later changed their position wanted it. We were also very cognizant of the possibility that bias be carried forward by those risk assessment tools, so we required that they be validated tools. We required studies and feedback loops of information so that we could change and alter and amend our risk assessment tools if they are carrying forward bias. Whenever you rely on a piece of information from a criminal justice system that has bias baked into it, prior convictions, prior arrests, prior failure to appear, it's going to carry some element of that bias forward. So what are the best ways to mitigate it while still relying on data is kind of the issue. But we always agreed on a risk assessment tool, but we always knew that it would need perfection and cognizance of the possibility of bias being carried forward.
Judge?
Quickly, I was saddened by that statement by the 100 organizations because I believe that risk assessment, they recommended nobody use risk assessments, period. Then they cited a bunch of concerns. I agree with all of the concerns that they cited. They're all legitimate concerns we have to pay attention to about how judges use risk tools, what their limits are, what they can do, what they can't do. But to throw out the possibility of using science to try and predict people's success, not with an eye to detaining them, but with an eye, as was stated, to help us in a refined way release more and more people with appropriate supports, or most importantly, with no supports. And you need, whenever you talk about throwing out scientific help for judges in trying to estimate pretrial success of released people, You have to think compared to what? And let's remember what we have in every courthouse in the United States today. If you think we have a race-neutral, transparent, open, wonderful, effective system, we have nothing that approaches that. And so the way judges set bail all over America now is deeply ingrained with all of the problems in the American criminal justice system, all of which gets compounded in the end by using money to determine human liberty before their trial.
Yeah. Where do you think this goes? I mean, certainly many of the groups who signed that are the same ones who are important in the coalition that is electing reform-oriented DAs or the kind of changes that California is pursuing. If they are turning away from risk assessment, how much impact is that going to have on how this unfolds?
So I think that risk assessments are not going to go away. They are being used in literally hundreds of courtrooms across this country, and we're not going to roll that back entirely. But as the judge mentioned, there's literally one very small paragraph in this statement. It's released by the Leadership Conference. The first statement basically says we don't believe risk assessment instruments should be used because of racial bias and all of those things. And then it is 3 pages of principles and guidelines for, if they are used, how to use them carefully. And the judge raises a really important point, is the way the risk assessment instruments are constructed is science, it is scientific, it is a formula, yet the decisions about who is low risk, medium risk, high risk, those are policy decisions. Those are subjective decisions that we can make differently. What to do with somebody who falls into that medium-high category and whether to release them, perhaps with some supports, but to make the decision not to detain. Those are all policy decisions that we need to make, and we need to have the discussions to change how risk assessment instruments are being used.
We talk about how complex the cross currents are on this issue. That's the criticism from kind of the reform camp or the left. Judge, you have cited research showing that people who are not detained, who are not in pretrial, are less likely to commit future crimes. So there's a case in terms of public safety for keeping people out of detention. On the other hand, there is always the risk, as we talked about in the last panel, that someone who is diverted will commit another crime, maybe even a serious crime. You're looking down the barrel of an effort to repeal this already from the bail bonds. And how vulnerable is this kind of reform to just simply the one bad example?
That's been a problem in politics for a long time.
Yeah.
Starting with, we all know about the Willie Horton issue, and that fear that lingers in the minds of elected officials, judges. But I think we've moved past that in California. We passed Prop 47, we passed Prop 57, we passed Prop 64, major criminal justice reforms, and in this year SB 10. The tough on crime time is in our rearview mirror, and it was proven to be wrong in the view of Californians, and we need to do it a better way, a different way. So I think that lingers for some. I think the referendum effort by the bail industry is expected. If they get the signatures, they actually put a stay on implementation of SB 10.
I was astounded to read that, actually. As a California resident, once they get the signatures, the law is in abeyance until the actual, so that could be 2 years.
Exactly, and could be a strategy in and of itself, to buy another year of time to continue to operate, which is exactly what the plastic bag manufacturers did when we implemented our plastic bag ban. They qualified a referendum, they got another year of making their plastic bags, and then the Californians summarily rejected their effort.
Could I just add that it's really important to note that the scholars disagree about risk assessments and a lot of things, and a lot of thinkers disagree about the right, best way forward. There is only one group in the United States of America who advocates with a straight face that we ought to use money to decide liberty, and it is the people who we have enabled down at the justice marketplace. We have allowed bondsmen to charge a 10% fee and line their pockets with debt from desperate families trying to get people out. Nobody is making the case for keeping money in America as part of our justice system, except the bail bondsmen who profit from it. If I could just add,
Yeah.
this
And then we'll go to the audience.
business about risk assessment, I just want to give a really quick plug because it's such a complicated topic. There's an article coming out in the Yale Law Review very soon, written by a brilliant young scholar named Sandra Mason at the University of Georgia, which, if anybody can get it up to read a law review article, this, which is coming out very soon, will explain all of the policy things, all the science things, discusses all the issues we've been talking about risk assessment. And importantly, she does not call for throwing them all in the trash. So,
All
sorry.
right, I was just thinking that it's good to be reminded that there's something going on at Yale Law School beside drinking parties.
Yeah.
Beside keg parties.
As an umbrella, that hurts.
Right? Yeah, just in case you were wondering. Let's go to the audience in the back, since we didn't do that before.
As someone who's new to this topic and not familiar with risk assessments, can you give us an example of low risk, medium risk, and high risk?
Sure.
And the other question,
You have your next panel.
and the other question is, does mental health or drug use, which from what we heard accounts for substantial number of people that get into the criminal justice system, do they somehow appear within how we measure risk and what we do about it?
We're going to hear more on that in the next panel, but if you want to give maybe a quick answer about how the instruments work.
Sure. I don't want to get too into it, but certainly different risk assessment tools have different factors, and some ask questions about substance use, about prior mental health, medications, things like that, and can be factored into whether somebody is low, medium, or high risk. Others do not look at those factors. The other thing is that there's a huge range across the country of how good these risk assessment tools are. All of them are certainly not built the same.
Do we have another question? Down here? Yeah.
First of all, thank you very much. A very, very interesting conversation. And I believe in everything you're talking about. But I'm also aware that the murder rates in Chicago and Washington, D.C., the numbers of shootings are going up. And it does happen in communities of color, not only. But there is a challenge there. Can we talk about that? Thanks.
Balancing reform and safety. I mean, that clearly is an issue.
I'll talk to New York City. So New York City is the safest big city in America. We have the lowest crime rate that we've had in 55 years. Last year we had 341 murders, which for a city of 8.67 million is remarkably low. And what we've also done in New York City is we've dropped our jail population from a high of 20,000 back in 1992 to around 8,000 people in jail on any given day to day. So what New York City shows you, New York City, is that you can actually get more public safety by having fewer people in jail. Incarceration does not actually deliver public safety. Certain communities are certainly more hard hit and feel the impact of violence and crime far more than others. That's not at all to gloss over that fact. But the fact that New York City has used incarceration and jail less, to the point that was made earlier, that even just 2 days in jail, 3 days in jail can actually lead to what's known in the business as a criminogenic effect, meaning somebody is more likely to have continued contact with the criminal justice system, to get rearrested, to offend again. If you keep people out of jail in the first place, it means that they get a fighting chance to stay with their families, to be in their jobs, to be in their communities, and we know that that's what keeps people and communities safe.
And money bond never keeps us safe.
Yeah.
If I had a chance to explain to you how it works, it would shock you.
Yeah.
But it has nothing to do with safety.
What do you believe the impact of SB 10 will be on crime rates and safety? What was the research that you were able to look at?
We think that there will be a very positive human impact for those who, as I mentioned, lost their jobs, kids, homes, cars. We think that people who can be safely released are not, and that when they're incarcerated, you're more likely to, pre-trial, you're more likely to take a plea and have a conviction on your record, which hurts your ability to get housing and jobs and student loans. And
thus increases the risk that you will offend again?
Yes, by learning to be a criminal potentially. And so we think it's better to be in your community with your family, working at your job, if that can be safely done. So we think this is going to keep crime rates low.
That was a great conversation. Join me in thanking the panel. Thank you all. Really fun. Really appreciate it.